CW agencies. Here's one where the taxpayer loses. So in this case, it's kind of an older case on software, going back to 1998. And really what we talk about is they didn't keep great evidence of documentation. The key strikes on it is they really didn't show the variables that they were dealing with in software development. And most clients don't, which is, again, where they fall down. The clients that do always win, every single time. If you can show the variables, unless the CRA can refute it and show you that the answer was readily apparent at the time you did it, and they'll do that. Has anyone ever had the CRA come back and you say, well, gee, Dave, if I query that now on November 2012, yeah, there's lots of answers there because 10 or 12 of my competitors have discovered it. But when I was doing it 18 months ago or 2 years ago, back on February 7th, 2010, there was no answer. The sophisticated CRA reviewers will use something called a Google Wayback Engine. You ever hear of that? Yeah, you just go to Google Wayback Engine and you say, oh, okay, sure. Let's see what Google would have responded on February 7th, 2010. Boom, there's the articles. And if the article's in there, that's it, you're dead. Do not pass go, they got you. But at the same time, I would tell my client, hey, they're going to use this, so why don't, if you say you actually did these articles, you just forgot to print them, let's go back and do it. You already did it. There's nothing wrong with printing it now, since it was the basis for what you did. Let's go grab the evidence and have it in there at the beginning. Right? So we have no weak links. Okay? So the three strikes here is, they didn't really talk about the variables of uncertainty, but then again, software claims at that time were in their infancy. They really weren't as developed with the kinds of issues and objectives or examples that we have now. The three strikes against this guy, three main ones, there's probably about 5 or 6. One, no hypothesis, which means they didn't identify the variables, basically. They were weak on the standard practice, they talked a little bit about it, but they really didn't identify any variables or systematic investigation. They didn't keep any records of experiments, and probably one of the worst ones, they used a guy like myself, a third party who had nothing to do with it, expert witness who wasn't involved in the project at all, to be the expert witness in court at the end about why it should come in. And I would say that typically, since both the CRA and the court say that the SR&ED should be performed by the performer, not a guy like myself who knows how to, quote unquote, shoehorn whatever you did to make it fit into, look like it meets the legislation. So those three things together, I think, combined that the judge really didn't have a lot of good faith in the SR&ED work of the client. There was too many weaknesses. Right? So again, if you're not able to identify variables, it's hard to correlate the work as being SR&ED versus developing features and functions. Nashen is another one with software development. It was an informal procedure. This is a very important point that I talk about in some of my other courses, but when we're talking about going to tax court, there's an interesting process that seems to go very quickly. You can file your notice of objection, wait 90 days, and then appeal to the tax court of Canada, Section 165 appeal. There's 2 ways to do that. You can go a general procedure, okay, which usually costs you $30,000 to $40,000 up front. You're going to have to hire a litigator. And it tends to go very quickly to the 6th stage, which is called the discovery, and that tends to take 2 to 3 years. Now, in the interim, the way the CRA really sticks it to any client who dares to challenge them in court, and they do this incredibly unfairly, in my opinion, which is why there's a lot of talk about arbitration councils or something better than this, is that in that 3-year period, they'll say if any of the issues that you're objecting on apply to the current claim, we're going to hold all those too. So I have clients who say, well, we know we're right, we agree, we think we're 100% right, but we can't give up $300,000 a year for 3 years because that will bankrupt us, so we're just going to do a deal. Okay? And they lose their rights, or they ignore their rights, because it's not efficient for them to fight the good fight, even though they're 100% right. Now, my strategy is to say, this was happening all too often, and CRA were getting smug. We don't think you're going to go to court. You're going to threaten to go to court, but we know it's just really not a good business decision. So what I'll do is I'll say, no problem. There's another kind of appeal under the Act that a lot of people aren't aware of. But I can elect to limit my amounts in dispute to $12,000 per taxation year. We're going to talk about some of these, which is the recommendations I'm making to other practitioners now, and it's starting to happen. We're seeing a lot of these judgments, 2 in the last 2 months of one of my associates. It's called an informal appeal. I can represent my client. which is better, because I have to teach the lawyer what to say anyways. They don't really know much about SR&ED. Pretty much write the whole argument. If I can be the front guy, I can actually do that much better than the lawyer, because he's going to have to come talk to me after each thing about what he's going to say for the next round. So what happens here is you file an informal appeal. It costs you $100. I usually pay that on behalf of my client. I represent the client. When I win, which I usually do, or I settle ahead of time, then I get a judgment published, and I only get my $12,000. But the point is that I usually make it to court within 6 months of filing. From the time I file the papers to getting my judgment, because you come into court and the judgment's going to happen that day, which is one of the things you do. You don't get a general procedure where you get to come back 3 or 4 times. Oh, I'm missing something. Let's schedule another date 6 months from now. It's done. You're missing something. Do your best, because they want to make a judgment, and they've got the next client coming in. So it's fantastic. So I use this informal appeal to say, all right, it's a $100,000 issue. Let's take a hit this year. We're only going to get the $12,000. But you know what? For each of the years in perpetuity, we're not going to have to deal with this issue again. When they try to deny it next year, I'll say, yeah, hey, listen, the tax courts have already ruled here. And now I have a very strong emphasis. The CRA is not going to tend to overturn the Tax Court of Canada judgment, because tax courts overrule CRA. CRA has to follow the rules under the legislation that the tax court applies, not vice versa, right? Our laws are passed by our elected officials, people that you and I vote for. CRA officials are appointed, like a police officer. They have to follow the law that's been applied to us. They can't make their own laws. They can't make any laws with their circulars or their papers or whatever. If their circulars or papers do not follow the Income Tax Act or application of it, the judge will comment that the papers should be changed, right? So again, the point here is they used an informal appeal, which was good. What they found was 2 out of the 4 projects were eligible. Ones that dealt with the methods to get the objectives in, were in. Okay? So what methods do we use for converting emails and for creating documents on a mainframe so that we can email them back and forth? So they had to develop, so they benchmarked standard practice that there was no existing methods to do this, that they went in, they developed their own methods for a mainframe computer to do this years ago, and the judge thought that 2 of those were in, and the other 2 were dealing with interface issues or optimal design, which seemed to be more business advancements than technological advancements. So again, one of the earlier cases, but again, how the courts are going to apply, in software in particular, the eligibility to saying it's the method to get to the answer. If the optimal method requires experimentation, it's good, but you can seldom illustrate an eligible project by just listing features and functions. We're saying those might be the indicators, but those aren't enough. Telling us all these new features and functions that you added could have been routine, or it could have involved SR&ED. Zeuter's one of the ones where, I mean, this is one of the ones that's very clear to me about what should be in and what should be out. Sorry, actually, just one point, I'll go back. Just before I do that on Nashen. Yeah, so on the definition of standard practice, they talked to IBM, who was their mainframe supplier, and IBM told them that there was no direct way that they were aware of, or any third parties that they were aware of, to email directly applications from the S400 system, the IBM system, as the client wanted. And they had to develop a method to spool files and embed functions to do that. So the fact that IBM, the developer of the system, couldn't give them a definitive answer was enough emphasis. They didn't have to look at every possible one. This is kind of pre-internet, late 90s, so there wasn't Google back then. They did a reasonable search, the judge felt, based on the issues in question. So if you have a very large, reputable supplier telling you, we have no idea how to do this technology-wise, and it's our own system, that's very strong evidence of a strong basis of departures from standard practice. Sorry, going right ahead to Zeuter. Zeuter's one of the ones where we had a university professor here who basically, is one of the ones that is cut and dry to me, who hired a whole bunch of students to take an encyclopedia and transcribe it all onto CD-ROM. CRA quite rightly said, copying information and putting it from one form to another does not involve any hypothesis or uncertainty. And they were right. They basically said, presentation of already known information does not constitute an advancement. Okay? So again, the client really had little basis on there. or an advancement in science or technology, despite being a PhD at a university, right? So you'd think, hey, someone's very skilled, maybe everything that they do is eligible, but again, unless you have hypothesis, and I would say hypothesis meaning variables, you're in big trouble on that one.